I'm just saying this because like young arbitrators, young lawyers who want to be arbitrators, they have to start by seeking internship in big law firms and as well in arbitration centers. We have people who've come from Cameroon, from England to do internship in Rwanda. So for them, at least to know what the practice, the practice of arbitration. And that's one way of learning. There is also another solution to the problem is to engage government. And that's the role of African Arbitration Association, the role of advocacy. If we know that government institutions, government officials are involved in signing many contracts, they are the people also who appoint arbitrators if their agencies are involved in arbitration. So we have to talk with them, tell them that we have right people who can also serve as arbitrators. But as I said earlier, you can't engage them if you are not showing them that the people you are proposing are capable. Because they can't appoint somebody because just he's from the country or because he's black. They have to appoint somebody knowing that the person is able and competent. So I discussed sometimes back with a minister in Rwanda when we were like, he asked me an advice to appoint an arbitrator, and he was proposing between somebody coming from Nigeria and somebody coming from Germany. And I told him on equal qualification, if you think they are both capable, you can't take somebody from Germany if there is an easy flight from Abuja or Lagos to Kigali. The distance matters, so you understand that it reduces the cost. But you can't just do it because the person is from Africa. You can do it knowing that the person is able. You can't recruit a nurse to cure or to treat the cancer. So if you know that the person is able to do it, nothing prevents African officials to appoint their peers. And there is also that role of lawyers. What I've observed, rarely you will see an arbitrator who is appointed by lawyers who are not also arbitrators. So in many law firms that come in arbitration, other than as counsels, many of those lawyers are also arbitrators. So I wonder why they don't appoint their peers. So if they can't appoint their peers, sometimes we blame arbitral institutions. But the roles, as you know, it's a party autonomy, and the role is given to councils to propose. And even if where we have that power of appointing, we do the list procedures. On list procedures, you give them names. If I give like 4 names and somebody proposed the person who is in London, so I will retain the name that has been proposed. So that's the reality. I think the last one, it's, as I said, to be members of arbitral institutional panels. At least send a CV, write a right CV, send it, and make sure that they can easily select you. I've seen CVs, people who applied, but when they send a CV, they don't mention area of expertise. You don't know if it's after his law school, if the person has sat in arbitration, if somebody has like a specialty in construction. So you have to be detailed, because sometimes nowadays we are using the machine, the system that can select people. So if your CV is not well drafted, I mean, that will be an issue. I think we have also to teach people about presenting their CVs in the database or panels. And as well, multiply opportunities for networking and communication. As we communicate with somebody, as we know each other, it's easier to remember that I have a good arbitrator, I've seen him or her presenting in this conference, I've read one of his or her paper. So it's easy to just have that reference to the person you know in Africa, if you know that person, if the person attends conference. So I think African Arbitration Association can also work on that aspect, trying to make sure that we have many conferences and at least affordability of the cost for people to attend the conferences, and make sure that those conferences are not competing with the existing institution, but are aiming to promote arbitration in Africa and arbitration involving Africa for African arbitrators. Yeah.
Thank you, Fidel. Are there reactions among the panel to what other panelists have said?
Perhaps I could just chip in a word in reaction to what Dr. Emilia said. When I talked about young people making sacrifices for training, I'm talking from my own personal experience. Of course, I know that if it took the elderly ones 20 years to get to where they are, it shouldn't take the younger ones the same number of years. But the truth is that if you want something, you must pay the price.
Of course.
You must pay the price in training. You must pay the price in attending conferences. You must pay the price in making yourself known and visible. So I'm not saying that everybody should, it should take everybody 20 years, but I'm saying that commitment and focus on the part of young ones is very, very critical. Thank you.
Thank you.
I was going to say that I think what we're doing now is we need to consider inclusion. So being inclusive in every single thing, not just when we're appointing arbitrators. So something like the panel, for example, for every single conference. Nothing stops the Chartered Institute of Arbitrators, and even for us, our conferences going forward, to ensure that on each panel, there is male, there is female, there is a young person, there is a non-lawyer, if necessary, but it's massively important because that is the outward-facing side of, this whole talk that we're doing. So I think maybe for conference organizers, that's something to seriously consider and think about. And in addition to that, we need to hear new voices. We need new faces. So someone like me, I attend a conference, somehow before I say, Emilia, my hand is already up. I have to ask a question. So that's not it. I'm not saying I'm not grateful for being put on a panel, but they're new faces, they're younger, new voices. And when we say young, we're not necessarily talking about young in age, because there's some a little bit older people who came into arbitration a little later on in their careers, who are successful in their primary careers as well. So let's just be clear on that. But we do need new faces. We need to hear new voices, because we need to give new opportunities to people. So conference organizers, maybe that's something to consider. And the last thing is on the pledge. So there's been talk, and I'm also involved with a group of other, funny enough, not very African, non-African practitioners in drafting a pledge for Africa. So that pledge, we've actually done the first draft, but we wanted it to mirror the AIRAB pledge, the Arbitral Women pledge. And so we discussed it with the leadership of the Arbitral Women. There was some, we're still sort of discussing. But I'm asking myself, is the pledge the right way to go? Because ultimately, who are we asking to pledge? Am I going to be asking White and Case to pledge to appoint African arbitrators when, if I have an opportunity to suggest African names, I suggest foreign names. So who is the pledge? I don't know the answer, but I'm beginning to question whether the pledge is the right way to go. One thing that I'm convinced we need is when those who produce statistics, institutions, whatever, we need them to also tell us, Fidel, how many women have you nominated? Not appointed, but nominated. How many young people did you nominate? How many Africans did you nominate? Because if I've been nominated 3 times, for example, and I haven't been appointed yet, it means I'm doing something right. My peers are taking note. It's only a matter of time. I will get there. But I wouldn't know if I have been nominated. If an institution is saying that in 2016, we nominated 10 women, and out of the 10 women that we nominated, 5 were appointed. But in 2017, 10 were appointed. In 2018, 15 were appointed. We can see that progression, we can track it. Because for me, I think that just by nomination alone, I think there's some value in being nominated before you get appointed. So I think we should not just discount those other levels as though they do not matter. Thank you.
Sorry, I just wanted to ask Amelia one question in terms of the pledge. You said you were doubting whether it made sense to ask, who are you asking to take this pledge, and are we asking the big firms to? And then you expressed a certain doubt, and I wasn't sure that I fully understood it, so I just wanted to understand what you were saying.
I think for me, I'm asking myself, so maybe I should backtrack and say that my philosophical leaning is of Africans can do whatever they can for themselves. I do not believe in the dependency theory of being dependent on being helped by former colonialists. And that's where I'm coming from. For me, really, if we can generate, and we do generate, a lot of contracts, a lot of transactions within each African country and intra-Africa. And that's a dimension we're really not even looking at yet, the intra-Africa disputes. So if Madumere talked about domestic arbitration, that is a huge untapped area. So if we alone were just appointing Africans for African disputes, honestly, with due respect, we really do not need, external people having to appoint us, because we would generate enough appointments for ourselves. That's just what, and I don't know if my thinking hasn't matured on that.
I'm just going to answer, and then just so if you take a firm like White & Case, White & Case has offices all over the world, right? So it's not a European firm or a North American firm. So I do think you should be asking the White & Cases of the world, why are you appointing arbitrators from regions of certain of the places you have offices, but not all of the places that you have offices, right? And some of that has to do with where we do arbitration and where we don't do arbitration, but why not Africa, right? I mean, we're everywhere. So why wouldn't we be asked to make the nominations that we make, because we're making the nominating out on a big chunk of what's really happening, right? If you don't ask the big firms to do that.
I take that point, and again, like I said, my thinking hasn't really matured on this point, so that's very helpful. But again, for me, especially African governments, have no business appointing foreign firms. They have no business doing that. So an African government, especially African governments, they must appoint a local firm, and the local firm would have a relationship with foreign firms. So a Whiten case that is Whiten case Zambia, as far as I'm concerned, is a local firm that is part of that larger partnership. But the government should then be appointing Whiten case Zambia and not calling Elizabeth in Paris. And then Elizabeth is coming back to maybe Nigeria to say, oh, what is the Nigerian law on this? That is the point. Because if the government appoints a local firm, that is the lead firm, yes? And then the local firm has a relationship with the foreign firm. So the foreign firm will still be on board because, of course, we need that expertise. But the local firm is the one that the government has appointed. I don't know if that makes any sense.
Yeah, and then we'll move on, of course. But that's government, maybe a special case. There's a lot of private parties. Fidel.
Thanks a lot. I'm just going to respond to Emilia about the nomination of female arbitrators and young arbitrators. To make it easier, let me just explain how we nominate people. We have two kind of scenario. Scenario number one, you have a case whereby parties appoint their arbitrators. In such a case, we only confirm or change it depending on the reason, if there is like conflict of interest or other issues. The second scenario is whereby parties have said that the center will be appointing. When the center has to appoint, we do what we call a list procedures. In a list procedures, we propose generally 4 or 5 names. And how do we propose those 4 to 5 names? We base on at least 3 things. Number one, it's a language issue. If arbitration will be conducted in English or French or any other language, we see people who master the language. Criteria number 2, we see also the complexity and the field of dispute. If like you have a construction dispute or IT-related dispute, you just go through the list of our panelists to see who fits in that field. Number 3, we see also the cost, and this is very important. If for a small case, a case involving a small amount of dispute, we prefer appoint or nominate people from the region, like Kenya, like Tanzania. We consider also Nigeria to be the region because with Rwanda Air flights, it's not expensive. But when you have like a dispute of less than $1 million US, you know that the cost would be high for like bringing somebody from US. You can't nominate people from there. But at least nominees have to at least meet the requirement relating to language issue, relating to qualification. If it's IT related, I can't appoint somebody who is only in business law. So I have to make sure that somebody meets also the criteria. And that's why I said that how do you send us your CV and how do you update them? Because you also need to update. That's what I can say. But to be concrete, we always make sure that we propose a female and a male at the same time. Why? In Rwanda, our constitution says that you should have at least 30%. 30% is not respected in our statistics because we don't have many female who are part of our panel, but at least we are committed and we are bound to do so. So if you want to join our panel, make sure you will be one time a nominee and sometimes appointed. Thanks.
Okay, thank you, Fidel. We're almost out of time, but that's because somehow the clock made 10 minutes disappear. So I'm going to take one question that's been submitted and one from the floor, and then we're going to have to stop. And the question that I'm going to take that's been submitted is, how much does the narrative of corruption likely affect confidence in the appointment of African arbitrators? Is there's someone on the panel who'd like to answer that? Sure. Yeah? Sure, please, Amelia.
I think we do need to be careful. So it is corruption in the judiciary, or generally corruption everywhere, in wherever, but not corruption in arbitration. That is massively important, that we don't conflate and confuse things. So naturally, with the noise about corruption and the reality of corruption, so it's not just noise, there is a reality of corruption. It can work both ways, actually. So I would actually expect that with the statistics from the Nigerian Bureau of Statistics and the UN ODC Joint Corruption Index that they released, that showed that the judiciary is the third most corrupt public institution in Nigeria, that would push people to arbitration. Because that is an indicator to avoid the courts, if you can, effectively. That's what that statistic should be saying. So personally, I'm not privy to, I haven't heard any allegation of any form of corruption in arbitration on the continent. No. But arbitration would always feed into that perception. But I would expect it to be a positive thing for all.
So I've heard something going along the lines of corruption. Someone told me maybe 6 months ago, in-house counsel from Mauritius said to me, what seat would you recommend, but please avoid the African continent because of corruption. And you'll be happy to know, Fidel, that I said, if you want to be totally sure, go to Rwanda. But I do think that was the first time personally I had heard that, but I think it's got to be out there. We'll take one question from the floor. I see the hand of you. Yes, you who's just stood up.
Good afternoon, our panelists and the coordinator. My name is Adenchin Makandik, and I'm from Alice Zubira Associates. I want to thank my principal for sponsoring I and my colleagues to be part of this conference. So grateful, sir. And I want to contribute concerning the Africanization of arbitration. And I want to say some of the challenges, even though we've discussed a lot about that, I see that one of the challenges is the economy of Africa and the fact that lack of basic infrastructure tends to discourage parties from deciding African states to be the seat for arbitration. Because, and what can we do about that is to have competent leaders elected into offices, because when we have that, then we can have basic infrastructure like power, and then that will translate in having more arbitration proceedings holding in Africa, and then the siting of the seat can also bring about appointment of African arbitrators. And I also want to say that for the young lawyers, our young arbitrators, we need to also encourage seniors, like it has been suggested, to sponsor their juniors, just like my principal has done, to come for such programs and give them experience. And then on the final note, I want to say that we in Africa need to make sacrifices, because why the system is being seen as arbitration hostile is because we, the actors, sometimes take the instruction from the clients to go and appeal against an award, even though we know that that appeal is just frivolous, just because we want to get the fees. Therefore, we also need to make sacrifices to be firm and sacrifice that extra fee we may earn from a client, just because we want the system to be more arbitration attractive and to be a hub or a home for arbitration. Thank you.
Okay. That wasn't really a question, but are there any comments in response? We're out of time. Okay, well, thank you very much. Unfortunately, we're out of time. Thank you.
I did say that it was going to be so engaging, nobody was going to nod. Did anybody nod around you? Eh? You said? No. Did you say no? Yes, you said no. Or no, you said no. All right, please appreciate the panelists. Thank you so much, Madam Moderator. Before we leave, we'd like to welcome our chairman, Nigeria branch, to please appreciate every member seated up here. Let's welcome Madam Doyin Rhodes Vival, and the gifts are coming.
Thank you very much. The day is far gone, and there's not much time to say anything, but I just want to bring something to our attention. When I was outside during lunch, a gentleman, one of our important delegates, you are all important, came to me and said, he just wants to tell me that we are forgetting something, that not all of us here are lawyers. Yes. So yes. I apologized to him, and I said, I'm really sorry. Normally at our conferences, we always make it clear that we're not all lawyers, but I think we really goofed this time. We're not all lawyers, so don't let's forget that. This is not a lawyers' conference. And in fact, last year, we had the white-themed gala night, just to make the point that it's not an association of lawyers. And then the second thing I want to mention is, I think we really have to take the issue of funding seriously for the training of our young arbitrators. Okay, I've been lucky, I must tell you. I've had a lot of trainings, but my father sent me out to all the best schools, but he only educated me as far as my bachelor's degree. I have a master's in Unilag, I have a master's in King's College London, and I was on scholarship in King's College. A lot of training I've gone on, my employers paid for it. So I think there's a challenge to senior lawyers. You do football competitions. Why can't we do competitions? Every year, pick at least 3 young people who have shown the potential and send them on these trainings. Because let's face it, if you want to do ICC arbitration, ICC wants to know whether you've attended a PIDA training. It's expensive to attend a PIDA training, although I'm sure very soon they might start citing some of this in Nigeria. But the fact remains that these things cost money. So, and it's up to the senior lawyers, I think, to make an effort to put funds down. The senior law firms, the top law firms, they are there. I don't want to start mentioning them. I'm looking at all of them, and they know I'm looking at them. You do football competitions, do competitions, and let's start funding and assisting some of our young ones. It's for the future of Africa. Thank you. So,
Thank you, ma'am. And no, it is not juju. They are just works of art. Beautiful ones at that. All right, smile on count of 3. 1, 2, 3. Oh, Madam Mayor smiles. Thank you, sir. Thank you all. Thank you so much. Madam Moderator, thank you. Dr. Emilia, thank you. Diane Okoko, thank you very much. Dr. Fidel, thank you. And Mr. Chikwendu Madure, thank you all so much. Smile for Africa. Thank you. For those who've been asking for access to the Wi-Fi, just in case, the Wi-Fi name is CIArb 2018-2018, and the password, all in small letters, is CIArb NG12, NG12. Some people have been asking, just in case, please. The password again is CIArb NG12. And just so that we know, just in case you didn't know, how many of us use the Taxify app? Taxify? Okay, so many of us have cars, so we don't use Taxify and Uber. Okay. Taxify is a cab service just like Uber, and is offering free rides to all of us who are delegates at this conference. Somebody has been enjoying it up till tomorrow. All you need to do is download the app. It's an app. Application on your phone. App. Yeah. Download the app. Put in your card details. You go to promo code and you put in CIArb. Don't worry, we'll put it up soon. CIArb 2018, and you get free rides today, tomorrow, all around Abuja. Please don't try it in Lagos or Port Harcourt. It works only where? In Abuja. Our final discussion for today is adjudication in constructing contracts, challenges and opportunities. And our moderator is the lead counsel, Onoge Theophilus, Abuja. Please, let's welcome Ewuni Onoge Theophilus. Ewuni. Panelists, we have Chairman, CIArb Zambia Branch, Director, Ranking Engineering Consultants, Lusaka. Please, let's welcome Suzanne Rattray Alavian. Welcome. Secretary, CIArb Kenya Branch, Partner, Steg Consultants, Nairobi. Patrick Kisia is here with us. Shansa. And we have the Executive Director, Dantata and Sawo Construction Nigeria Limited, President, Federation of Construction Industry, Nasiru Dantata. Welcome, sir. And finally, the Managing Director, Perry Formwork and Scaffolding Nigeria Limited, Stefan Oceanhofer. Please welcome him. Thank you, sir. All of their bios are within the brochure. And of course, just so you know, they're all non-lawyers, except of course, Ewuni. Over to you, Madam Moderator.
Good evening, everyone. It's a pleasure and an honor to be here. In our session, we'll be discussing adjudication in construction contracts, challenges and opportunities. Adjudication is a unique. Before we go on, I would like to remind the audience that we'll be using Slido, and we are all familiar with it. And you can type in your questions and upvote questions as we go along. So adjudication is a unique dispute resolution method designed for the construction industry, given the nature of construction projects and how complex they can be. So people usually confuse adjudication with litigation, but it is an ADR method separate from adjudication, from the usual adjudication that is used interchangeably with litigation. To help us throw more light on adjudication and to demystify the process, we will start with Nasiru, who is a civil engineer. And Nasiru, could you kindly give us a general overview of adjudication and dispute adjudication boards? Thank you.
Thank you. Good evening, ladies and gentlemen. As mentioned, we are all non-lawyers, so we will, of course, give the perspective of adjudication from the technical point of view. Adjudication is a first step that is recommended before arbitration or litigation. Normally, arbitration is a dispute resolution mechanism that is built into the contract as a first step for dispute resolution. It has two forms. It can come as an ad hoc adjudication instance, or it can be a standing adjudication process. The ad hoc adjudication process, the committee or the board consists mainly of 1 or 3 adjudicators. Is set up when the dispute arises. That is the ad hoc adjudication, while the standing adjudication is set up at the beginning of the project. The adjudications are carried along as the project progresses, and then whenever a dispute will arise, then the adjudicators are, of course, then well informed to make a quick decision. Now, going by the word quick, adjudication is set up in such a way that it's supposed to be quicker and easier than the other more legal processes. Normally in adjudication, the party that has a complaint will, of course, give notice of such complaint. The adjudicator, once the board is set up, the adjudicator will now call for documentation from the 2 disputing parties. Then it is through those documents, normally the adjudicator is able to form a decision. The procedure is supposed to be quicker. Normally, the decision, the whole process should end within 12 weeks. And then once a decision is made, there is only a 28-day window, just a 4 weeks window for the parties to either agree and abide by the resolution, or they can file a notice of dissatisfaction, whereby then the other modes of dispute resolution, be it arbitration or litigation, can commence according to, of course, the terms and conditions of the contract. I think in a nutshell, this is what adjudication is.
Thank you so much, Nasiru. Stefan, could you help tell us the Nigerian experience, your personal experience with adjudication in Nigeria?
I have worked here in Nigeria since the year 2000, mainly in public contracts, also in large-scale industrial projects, and I have not seen adjudication or dispute adjudication boards being used in Nigeria. I would even go a step farther that at least in public work contracts, arbitration is not very common here in Nigeria. For example, the Ministry of Work is utilizing a quite old set of standard conditions of contract, which is based on some ICE form of contracts from 1973. FCDA, that is here the Federal Capital Development Agency and Authority here in Abuja, is utilizing a modified Red Book 1999 version, where the Dispute Adjudication Board has been replaced by a mediator appointed by the multi-door courthouse here in Abuja. Some of the states here in Nigeria, they have their own sets of contract, conditions of contract, some also going back to the 1970s. And you find also quite often that you have a case-by-case or contract-by-contract draft up of, or writing up of conditions of contract. So the only mentioning of adjudication I came across is the standard bidding documents of the Bureau of Public Procurement, where adjudication is not properly defined. And in practice, I have not seen these standard bidding documents being utilized in tender procedures.
So, I guess in Nigeria, we have to inculcate the culture, and we need to get trained on adjudication more. Adjudication can be contractual, or it can also be statutory. In the UK, under the Construction Act, it's statutory. The parties to the contract have a statutory right to refer disputes to adjudication. You can't contract out of that. So, but in Nigeria, there's, like he said, there are little to no use of adjudication to resolve construction disputes. But the few that have it are based on contract, the contractual terms that parties have agreed to, not based on statute. So, Patrick, could you tell us if you have a similar experience in Kenya?
Thank you. Yeah, we certainly have adjudication in Kenya. The only difficulty, and which I realize cuts across many African countries, is that we don't have statute governing adjudication. So unlike arbitration, where we have a clear act that provides for the legal basis on which arbitration takes place, for adjudication, while we have a provision in various contracts for adjudication, we however do not have an act. So what we have done for the Kenyan situation is we have, as the Chartered Institute of Arbitrators, prepared the rules which we call the Chartered Institute of Arbitrators Kenya Branch Construction Adjudication Rules. Now the rules, in a way, help the parties navigate through the difficulty of having to run an adjudication process without an act. Now, of course, in terms of the Kenyan situation, we exploit the provision in the clauses which provide for enforceability. Now, with an adjudication, most of the provisions allow for a binding effect of any ruling of an adjudicator within 28 days of the ruling being rendered. So that within 28 days, the ruling of the adjudicator becomes binding and cannot be overturned even by the arbitrator. However, if a party were to prefer to move to the next step, I think Nasiru was talking about that, the adjudicator's decision still has to be complied with anyway, while you proceed to the next level of arbitration, or even if it were to go to litigation, you would still have had to comply with the ruling of the adjudicator anyway. And so that becomes a way in which we try to navigate through the difficult waters where we do not have a statute. We have, however, crafted a bill which is pending before Parliament, and we'll be hoping that for Kenya, maybe in due course, when the members of Parliament have decided to finally focus on construction, we might possibly have the bill to be passed, and we might possibly have an act sooner than later.
Thank you so much, Patrick. Given in Zambia, I was wondering, Suzanne, what has been your experience with adjudication?
Thank you. The Zambian experience seems to be somewhat similar to Kenya. We also don't have statutory adjudication as we understand it in the UK with their Housing Grants, Construction and Regeneration Act, or their Local Democracy Act. But we have provisions under other statutes which require certain types of construction projects to be adjudicated. And currently we have a Public Procurement Act of 2008 and public procurement regulations promulgated in 2011, which make it mandatory for any of the any public works projects. So any projects that are being procured by government agencies or semi-autonomous agencies, they have to be contracted on the basis of standard forms of contract, which are the two forms, there are two forms of contract depending on the size and complexity of the project. So for smaller works, smaller I think is, it used to be $10 million and less, I'm not sure what is the range now. The provision, the type of contract that it was a contract which the World Bank was promoting for several years, and they have a provision for adjudication. So there shall be, in the case of any disputes arising under the contract, there shall be adjudication, so it's mandatory, and the adjudicator had 28 days in which to render a decision. And the decision is a binding decision unless and until another process such as arbitration or litigation changes any element of that decision. So I think it's important to understand that the decision of an adjudicator is binding, if not necessarily final. And certainly from the point at which the decision is made, time is running within which there must be a further notice of dissatisfaction or some other measure in which you are going to escalate to the next stage. Generally, we have found in Zambia that the decisions of adjudicators have been binding as well as becoming final in many instances. For larger forms of contract, the ones which would go to international competitive bidding, as we would call it, they would be the standard form of contract that has to be used on those contracts are based on the FIDIC Pink Book, the one which has been promulgated by the multilateral development banks have been promoted for use on international construction contracts. And under the FIDIC Pink Book, we have the Dispute Adjudication Board from the 1999 version, and now we have the 2017 version, which is now the Dispute Avoidance and Adjudication Board. So although we don't have adjudication mandatory for any construction contract as defined in the UK Acts, we have mandatory adjudication for the public sector construction contracts in Zambia.
Thank you so much. That's good to know, Suzanne. And I was wondering, Stefan, what are the challenges that are inhibiting the adoption of adjudication in Nigeria? What do you think are the hurdles we have to jump over to get to adjudication being practiced fully in Nigeria?
First of all, adjudication as such is hardly known. So it's quite important that the involved parties or in construction process, the different professions involved should come to know what is adjudication for, how does it operate, what are the procedures, what are the advantages of it. One of the great challenges I see is also the enforcement, particularly when the public hand is involved. They might not accept some of the decisions, and since quite often the contractual relationships are not really at arm's length, there might be some taking of advantage of the stronger position of the ministries and the governmental agencies. I think one of the further challenges is to find sufficiently qualified adjudicators, at least in the beginning. There needs to be some experience level as well. Another point could be that they are unbiased. I mean, there are several points where adjudicators might be questioned whether they are biased. They might be partly even tribal questions or some other issues. Also, I think, being a member of the Chartered Institute of Arbitrators here in Nigeria, I think the direction of professions required.
Thank you. Thank you, Stefan. So, Patrick, in Kenya, where adjudication is practiced, what has been your experience with enforcing adjudicators' decision? I know in the UK you can approach the TCC to have the decision enforced. Do you have something similar in your... What happens when you have to enforce an adjudicator's decision?
For the Kenyan situation, the adjudicator's decision takes a life of its own, because what happens is that if you're a beneficiary of a ruling, all you have to do is to wait for 28 days. At the expiry of the 28 days, that decision becomes binding. And therefore, if there is any money to be paid on it, those funds have to be paid. And all a contractor, for example, has to do is to include that amount in the next IPC, interim payment certificate. And the engineer or the architect has no choice, or the conservator, they have no choice but to include those sums in the next certificate. Now, ordinarily, of course, if any party were to want to set aside the ruling, then you'd not go to court to apply for a setting aside. The only avenue available for setting aside an adjudicator's decision is by arbitration. And so you would never quite have a situation where you approach the court with the adjudicator's decision and ask the court to enforce it. All you have to do is to take that decision. If a party were to want to challenge it, take it to arbitration, it may as well be that the arbitrator's decision eventually finds its way in court. And the basis on which the arbitrator may have decided may as well be the basis that the arbitrator has so decided. And so you then have the entire batch of documents in court which involves the arbitrator's decision. But by and large, on its own, standalone, the arbitrator's decision does not find its way to court.
Okay, thank you. Thank you, Patrick. Suzanne, please, could you, I know we are trying to learn about adjudication more now, and given your experience in the dispute adjudication boards and with adjudication in your jurisdiction, would you say that adjudication is amenable to multi-party proceedings? You know, construction contracts have an interplay of different contracts, a subcontract, a supply contract, and most of these contracts may have different dispute resolution methods inserted in them. How does adjudication work well in order to bring all these parties under one dispute resolution proceeding, which is adjudication?
I think some of the principles which we know well from arbitration, for example, party autonomy, also come into play into the adjudication process. The disputes within a construction project are very particular. They are normally disputes about time and money. We need more time, or we need more money. And those are normally the things which are the things boiled down to in construction contracts. And when we have a contractor and we have a client, there is normally an engineer or project manager, somebody who is doing contract administration, so is making sure that both sides are dealing with their obligations and money is flowing and quality is there, and so they're doing the time management, they're doing the management of the quality, and they're doing the cost management. Now, when the disputes arise, if there are subcontractors and other people who are, it's very possible that a dispute is arising because of something that a subcontractor or another party further down the line has some responsibility for. And in an adjudication process, all of these individuals can be, with consent, come in. Everybody wants to get paid. And what comes out of an adjudication is I mean, sometimes people call it quick and dirty. It's a quick process to keep things moving, because an adjudicator is going to come up with a decision, and that decision is going to reflect in the next payment certificate that the project manager is going to issue. So everybody is looking for a decision to be made. And so normally we have the subcontractors who's waiting for the main contractor to be paid so that he can get paid, and the suppliers. Everybody has an interest in the adjudication happening and happening quickly, and decision being made so that a certification can be made, because everybody wants to put in their evaluation so that a certificate can be made. They can take those certificates to the bank and use them as collateral to get money for other things. So the idea is to keep things flowing. So I think the adjudication process, where it's something which happens within a short period of time, some of them are 28 days only, some it's 42 days. Under the large contracts, the fitted contracts, we have 84 days. These are very short time periods in which decisions are made, and generally the decisions are about whether this money is owed to this money is owed by this party to that party, or whether additional time should be allowed. So those decisions are made, and then they become enforced, because each month there are payment certificates that are issued. So what we find in Zambia in the adjudication process, by agreement, different parties will participate in this adjudication processes. They'll agree to provide information, as much information as can be provided and decided upon within that short period. And I think everybody who is participating in the construction process is appreciating the value of having an adjudication process. Now, the dissatisfaction that may arise, there is recourse. But for the purpose of the continuity of the project, we're not having delays and disruptions, the adjudication process is something which adds a lot of value for all the players.
Thank you, Suzanne. Nasiru, please, would you say compared with arbitration that adjudication is cost effective? Don't mind that this is a crowd of arbitrators. Which do you think parties would lean towards? Adjudication in a construction project, would they lean towards adjudication or arbitration given the cost when thinking about cost?
In terms of both cost and time, adjudication is favorable. Number one, of course, because of the time constraints, the fees are normally much smaller, lesser. So adjudication is much cheaper for both parties to partake in before deciding to go into arbitration or litigation. So in terms of both time and cost, it is better to go first with adjudication.
Thank you. So,
sorry, if I may add, okay. Of course, the standing board, adjudication board, is more expensive.
Yes.
But the idea is for a complex project, it will likely avoid any dispute in the life cycle of the project. So on average, even though it may be more expensive to have the adjudicators before any dispute will arise, but you are going to avoid further complicated issues down the line in the life cycle of the project. Thank you.
We could go to Slido now and see if there are some questions for us. From Anonymous, does the panel see adjudication stroke dispute panels taking the place of construction arbitration in Nigeria as has happened elsewhere? Well, what do you think, Stefan?
Well, as stated before, I think, first of all, awareness needs to be created. We have a bit of a different environment here in Nigeria than, for example, in Kenya or Zambia, where you have quite a lot of foreign-funded projects, World Bank or other development banks, where FIDIC, as mentioned before, is obligatory. Here we have our own sets of contract in Nigeria, so that means, and most of the projects are also financed by the either federal government or by the states. So the first dialogue needs to commence to put them on board. Also the ministries, the contractors. I mean, here we have Engineer Naziru as the representative of the Federation of Construction Industry as one of the potential parties to be invited also. And as stated earlier, architects, quantity surveyors who are really involved, discussing with them, maybe even having a form of roundtable where new forms of, and maybe up-to-date forms of conditions of contract will be discussed and agreed on. My preferred version, my own preferred version is FIDIC. I think it's the most commonly renowned in Africa. I know in the UK this new engineering contract is very common. I think that from the traditions in construction business here in Nigeria, the parties might be more familiar, easier familiar with FIDIC. As Engineer Naziru and Susan mentioned already, this dispute avoidance and adjudication board accompanying a project, I see it as a very large advantage. One consultant once told me, who is working in international projects, that his experience actually was that the parties were trying to resolve any problems before the dispute adjudication board came to site, partly that they didn't want to have a pile of problems in front of this dispute adjudication board, also maybe to save on cost, since the adjudicators are charging for their work. So these are things which the effect is a bit like having a referee on field, like in a football match, which is popular in Nigeria, easy to understand. The players will learn not to play as many fouls as if there is no referee on the pit. So I think, therefore, I think it would be desirable and advantageous to have it here in Nigeria as well.
Thank you, Patrick. Stefan, I'm so sorry. The next question is, if adjudication is an ADR method employed in the construction industry, will it not amount to time wasting before going back to arbitration? Patrick, could you help us answer that?
Yeah, my experience is that adjudication does not replace arbitration, but it may make arbitration unnecessary.
Yes.
And so it is not a time-wasting approach. In fact, as Stefan says, because an adjudicator is appointed at the very beginning of the project normally, and he goes to sleep and only wakes up when a dispute arises. And so when an engineer decides on any issue brought to him by the contractor, and the contractor were to disagree, or even the employer were to disagree with the decision of the engineer, then that party takes that to the adjudicator. So the adjudicator wakes up from sleep, decides on that one issue, and goes back to sleep. And the parties have to then make progress based on the decision of the adjudicator. Now, In other words, what then happens is that either party would know that there is a referee somewhere. And so they would end up making fewer mistakes. Now, the parties are not going to have to wait until the end of the project to revive disputes which may have arisen way back early in the project. But as and when the disputes arise, they are dealt with at a time that is not too wasted. And so issues are still relevant. The people haven't died. The consultants are still in office. And so at the time at which the decisions are made, the issues are still alive. And so that makes it easier and more relevant to deal with the disputes at that point in time. So in other words, it is in fact a better use of time than waiting until the project is over. And then you're having to look for documents which may be long lost, or people who have long lost the project. And so education becomes a better value to our construction in this way. But does not on its own mean that because there is adjudication, then a party loses their right to proceed to arbitration. They may as well disagree with the decision of the adjudicator and therefore proceed to arbitration.
Okay, thank you, Patrick. Nasiru, there's a question here I think you should address. Can we have an arbitration and adjudication clause in one agreement? I know, till you can switch from one to the other. Do you see that, both an arbitration clause and an adjudication clause in one agreement?
Normally, yes. Both clauses are to appear, and they, of course, serve different purpose. The adjudication is supposed to be the first step, upon which, if you exhaust it and you are still not satisfied, then you can move on to the next one, based on if you still feel you have a case. I think for Nigeria in particular, adjudication will really be a good tool, because oftentimes we as contractors are not really at par with the clients or with the owners, even though contractually all the rights are spelled out. But as contractors, we shy away from enforcing many of the clauses, even though on a daily or ongoing basis, we are, let me say, cheating ourselves. This is both typical for the public sector, whereby the owners or the clients is the government, more or less, and also in the private sector. This morning, before coming to this event, I was discussing an issue with one of our clients. We have a project somewhere in southern part of Nigeria. Let me not disclose too much. But basically, as we were talking, it got into a little bit of disagreement. I had said my own, and he's still convinced with what his team has told him. He is not in the country to see what is happening. But during the course of the discussion, he asked me, he said, "Oh, Nasiru, does it mean that these other jobs we are talking about, this is the way you are going to behave?" Oh. So in a way, it's a threat that, look, unless you agree to what I am just saying now, you might as well forget these other jobs. And to be honest with you, I give in immediately. I called my guys, I said, look, I got a call from the chairman, and you know, chairman is big brother, this and that. No problem, just go ahead, do as they like to protect this future business. So this particular client is a client which I will not like to go to litigation with. Honestly, it will not favor the business interest. It's not about the project in particular. And there are many instances where many companies that at least we represent in the Federation of Construction Industry, the major companies, we all have hundreds of cases where we can go for arbitration or litigation. I think adjudication will be a much softer approach, whereby we will not feel like we are out in public arguing our cases in front of a judge. This is, I think, good for Nigeria.
Yes, thank you. Thank you, Nasiru. So I think Nasiru has inadvertently answered the question, the next question, which is directed to Stefan. Does Stefan think contractors would welcome the use of adjudicators in Nigeria? Or would you want to say something more?
I think Nasiru explained it very well. I mean, also he gave the example of a private project. In public projects, again, the engineers here in Nigeria are governmental employees, so they are not independent, and therefore even the engineers' decisions are very often influenced by the interests of the ministry or the governmental agencies. Therefore, certainly contractors would welcome adjudicators to become a means of check and balance within the contracts, I would say.
Thank you so much, Stefan. And I also think the next question has been answered. Given that adjudication is unknown in Nigeria and the construction industry is not pushing for it, what prospects is there for its adoption in the near future? Stefan had spoken on the challenges to adoption of adjudication in Nigeria, but has there really been a push for adjudication in Nigeria? Would you say that, Stefan? Has the contractors, or has there been any move being made towards actually adopting adjudication in Nigeria?
I would say already by inviting Engineer Nasiru here to this panel, that is a push, maybe the first step, and he's a very open-minded person, and he's more proactive, I would say, in the discussions with the contractors, the construction companies, and there's a dialogue within the construction industry here in Nigeria. Him as a spokesperson, representative, might also to some extent be able to take it up to the public side, that means to the ministries and public agencies. And I hope that also, it's an opportunity for the Chartered Institute of Arbitrators, in my opinion, which should be taken up as well. So we have to join forces and hands and take it up together. I see as greatest obstacle in this whole thing really the willingness or unwillingness of reforms and implementation of new forms of contracts within the ministries and public agencies.
Thank you. Thank you,
Can I add something on that? Okay. I'd just like to add something on that quickly, because we are sitting here as members of CIArb, and we are dispute resolution professionals. That's what we do. And adjudication is one method of resolving disputes. And it's used not only in construction. There are other fields in which adjudication could be used as well. I think we need to start thinking about resolving the disputes and not about what, the question was asked about whether or not there's a point to the adjudication because you're going to go to arbitration. I think that sort of belies an underlying assumption that you don't resolve something. I think that's what we do. We resolve things, and I think that's where we need to apply our minds. Now, adjudication as a process is something which many different professionals are familiar with, and it has good particular applications in the construction industry, because this is a field in which keeping the cash flow moving is so important to the process. And so if, as a policy direction for Nigeria, that construction industry is something which is important, that is a sector of the economy that we want to grow, then it's something that will get some attention in terms of how can we facilitate construction processes. If the disputes are getting bogged down in long processes in litigation or whatever, then it's something which now this provides an opportunity for the Chartered Institute, providing training in adjudication, doing advocacy for introduction of contract forms which provide for adjudication, and also focusing on dispute avoidance. So I really think that we have to see what is it that we're trying to do. Are we trying to solve the problems for our clients? Coming from an engineering background, practicing engineering for the past 34 years, people come to me with asking me to solve a problem. When they need something, then how do I do it? And it's to provide them with a solution. And I think this transfers also into dispute resolution. Disputants come to you for assistance to resolve a problem. And if we have a toolkit, we have a variety of tools which we can use. If there are things which are fit for a particular purpose, and they are efficient and cost-effective for a particular purpose, why don't we use them? I mean, if we can use an adjudication process which is time-bound, so strictly time-bound that we're not going to be incurring a lot of fees in the process. If we have professionals who are trained, who understand the complexities of the construction disputes and who can render decisions in those restricted time frames, this is only going to be beneficial to the owners of the dispute. It's not our dispute, it's the parties' dispute, and we are trying to help them to resolve them. So I think there is a big opportunity to be able to bring improvement in the outcomes of construction projects if we pay some attention to developing a cadre of construction adjudication professionals, something which we are doing in Zambia currently, and I'm sure it's something that maybe here in Nigeria as well, working from the side of professionals as well as advocacy for adopting contract forms which provide for adjudication. It's going to be something which is of benefit to the industry and to the economy as a whole, because in most economies, construction is quite a significant part of the national economy.
Thank you. Thank you, Suzanne. So, Patrick, I was wondering, given your experience with adjudication, what are the disadvantages? We've heard about the advantages, how it's cost-effective, how it saves a lot of time, so the project can go on site, and it ensures there's cash flow to the contractors. So what are the disadvantages of adjudication?
You know, as recent as, say, something like 10 years ago, when arbitration was taking traction in Africa, many advocates, and we have advocates in the house, many advocates resisted arbitration and resisted ADR. The late Mururu used to say that ADR to the advocates who would prefer litigation, they took ADR to mean accelerated decline to revenue. Now, of course, you will all agree that arbitration is a field where we apply ourselves properly to resolve disputes. But I think to some people, adjudication therefore obstructs business towards arbitration. And that certainly becomes a disadvantage to some of our players who may find adjudication as a tool that cuts out business. Now, the essence of adjudication is to assist resolve disputes. The difficulty with adjudication, and particularly the way in which the clauses are crafted in most agreements, is to allow the employer to then have a higher hand in deciding on the adjudicators. Nasiru has just indicated that because employers are the bigger brothers in the playing of contracts, contractors therefore get disadvantaged. In virtually all contracts, the employer is supposed to notify the contractor of the name of the adjudicator prior to writing out the letter of acceptance. But many times that doesn't happen. Under most standard contracts, the adjudicator therefore should be agreed between the employer and the contractor. And it provides for the employer therefore appointing the adjudicator in the event that the two of them do not agree. Now, ordinarily, when a dispute arises and the employer realizes that they're under pressure and the pressure will only become worse when the adjudicator comes into office, the tendency is for the employer not to appoint an adjudicator at all. So that becomes a disadvantage in the manner in which adjudication is laid out in most of our contracts. I have looked at your own contracts here, and I realize in a way they replicate what we also have in Kenya, where the employer ordinarily has a higher hand in the field of adjudication. Now, the other disadvantage usually is that by the time at which the adjudicator is in office, the employer is still having the higher hand. And Nasiru has indicated that usually when you have a ruling on your hands and the employer decides not to implement the ruling, and of course comes through to intimidate the contractor has no choice. But if you had gone to court, the possibility would be you'd be holding a decree in your hands. Yes, many times employers still refuse to pay on the decree, but at least it is somewhere up there where one day you can rise up and enforce the decree. So those become some of the disadvantages we would have with adjudication. Possibly the other disadvantage we are now facing today is the entry of advocates into the field of adjudication. Now, I think for the advocates in the house, they may not be very happy about this, because advocates want to, I'm told, that they want to create a bit of darkness, as the good book says, that at the beginning there was darkness was in the deep, and I'm told that might have been the cause, or might have been caused by advocates. Now, the adjudication is to clear out and make light. Now, many times, because the adjudication process does not have statute, many times when we have the adjudication to be employed at the end of the project and advocates come in, they then remove the provisions for limitation of time. I have an adjudication, for example, where I started last year in February. I was appointed in February last year, 2017. And I was to arrive at a decision within 28 days of the appointment. Now, the very first thing that happened was the advocates asked for time to address me. And both advocates came before me, and both of them had agreed to lift and to completely remove the provision for 28 days, as the adjudicator had no choice. And I can tell you what, today, in October 2018, I'm still holding the ruling in my shelf because I have not picked it up. And they were supposed to take this 28 days from the date I was appointed. So there are issues which arise. Of course, on the ruling, one party has benefited. Now the thing is, that party would have been better off obtaining this ruling last year than having to receive that ruling in the days coming. And so if the advocates were wise enough, they would have allowed the 28-day period to remain. And of course then the benefits to accrue to their clients within 28 days. But of course to the advocates, who doesn't mind a bit more fees anyway? And so the longer the time, the better the pack. And that becomes a problem. And so those become the disadvantages that education is going through today. Of course, training is a bigger problem. And so we're not able to apply education in the manner in which it ought to be applied. And I think what we have to do a lot more is to create sessions where we have a wide understanding of adjudication.
Thank you so much, Patrick. Well, wouldn't you consider the 28-day period as being too short to really go into the meat of the matter for complex disputes? Don't you think adjudication is a slam and dunk kind of method? Would you say that the 28 days period is too small for certain types of construction disputes? What do you think?
No, in my own experience, 28 days is really adequate because you are not supposed to wait to the very end of the project. You would, for example, be dealing with one issue, whether the contractor is entitled to extension of time or not. So that one issue comes before you. The material are very basic, and because this is what we go through every time as construction practitioners, and so we know the tools by which extension of times are supposed to be evaluated. The issues are still live, so if it means obtaining data for the weather, rain patterns and all that, it becomes very easy. But if you have to wait to the very end, then yes, there poses a problem if the dispute is being resolved at the very end of the project. But for the periodic coming up and resolving disputes, 28 days is more than the time any adjudicator would require. Even at the very end, of course, there is liberty to apply for a bit more time. But it's better that the adjudicator does not allow for that window, otherwise then you blow out the time. So because we are involved in the industry, it is not foreign to us. We understand the principles, and in any event, we usually have 28-day cycle in every project for preparation of certificates, for holding site meetings, and to do evaluations from time and again, inspections. And so in a way, we are already used to the pattern of 28 days. And so to any construction practitioner, 28-day window is really very normal in dealing with any issue that arises on any project.
Thank you. Thank you so much, Patrick. And I'd like to thank our panelists who have been top-notch in answering questions and educating and enlightening us on adjudication process. We've come to know that it's a very simple, straightforward, cost-effective, and cheaper mode of resolving construction dispute, and it's being used in other industries, not just the construction industry. And in Nigeria, it would be welcomed, although there are some challenges we would have to overcome, like educating the people on how it's used, and then the contractors would welcome it, just that the employers might still have the upper hand in the whole proceeding. Because, for instance, under the dispute resolution clause of the standard bidding document issued by the Bureau of Public Procurement for construction works, it states that the adjudication is a dispute resolution method to be used for projects being financed by the budget. And then the parties have to agree on an adjudicator. Then when the parties don't agree, it is the employer that should request to the appointing authority to appoint an adjudicator. So the employer can just say, okay, I'm not appointing anybody, and then the matter just stays there. And you know, adjudication is a condition precedent to the arbitration clause being activated. So it's really dicey in Nigeria, but there's some move towards getting it adopted in Nigeria. So once again, I thank our panelists and I thank the audience for listening. Thank you and good night.
There was a troublemaker.
Don't get tired of clapping. Thank you, thank you, thank you so much. Thank you, Madam Chair, Madam Moderator, thank you so much. But before you leave, of course, you know it's our practice to welcome our Chairman, Nigeria Branch, to appreciate the moderator and the panelists.
Where's Mr. Ashola?
Very well. Okay, he's in. Okay. The gifts. Is she going to say something? If you're seated, please applaud them once again. Thank you so much. Those who are still in the hall are much better than those who left on any account. Even though some people stayed in the hall, at some point they weren't hearing anymore, they had to start playing Candy Crush just to be sure that they still stayed. No, I walked at some point, I was looking at some people's phones. It was better you did that to stay and listen, because your ears were working, than stepping out. So thank you. Presenters alone, and the moderator. One with your gifts. Please show the gifts. Yes. And
Time for tomorrow?
9.
They should be seated before 9. So we start 9 for 9.
Okay. So just before we leave, please, a few things to note. The forms from CLE that were passed around, please ensure that you fill them today and just drop them on your seat or hand to the ushers or give us at the table out there, because some, if they're not returned, they may not get their CLE points. You may not get your CLE points, and your numbers noted on the attendance list for those who have not returned. Imagine that. So please do well to fill and return. Also, our feedback forms. There were questionnaires that were handed out. We handed out about 500 of them. We're yet to get up to 200 back. Please don't go home with them. They are not yours. They are ours. Fill them and do well to just leave them on the seat right there. You can bring them out right now and just fill. It doesn't take more than 2.5 minutes. Please do well to fill those for us. Tomorrow, the start time is 9 a.m. We'll be expecting everyone in here, brightly dressed, at 10 minutes to 9, seated, so that we'll have 10 minutes to cool down before we start the hot discussions by 9 o'clock. Africa Calling, tomorrow we also talk about strategies for sustainability and commercial mediation in Africa. If it's been a great day for you, please turn to one person and say it's been a great day. If it will still be a great day between now and midnight, turn to the person behind you and say it's still a great day. There will be some tours within. In the program of events. Where? Okay. Somewhere toward the end of the brochure, you will see places that can be visited in and around Abuja. Please do well to use your Taxify when you go there, because the ride will be how much? Free. Yes, use your Taxify, but make sure you go with someone just in case, so that you don't land in Nasarawa State. And then tomorrow we put your picture on NTA and say this person is being missed. Have a wonderful evening. See you tomorrow. No, it's not. No, you're safe. You're safe. Go around, eat Abuja fish, and Dambo Nama, and Suya, Fura de Nunu. Enjoy it. See you tomorrow.
Thank you.